the next case to come before the court is Zaryki versus Breen. All right, so each side is going to have 15 minutes to present the arguments, and the appellant may reserve up to 5 minutes. And I'm ready to proceed when you are, and the other judges are too, it's not just me, I guess they're ready to proceed too.
Well, thank you, Your Honors. I'm Kevin Breen. I'm the appellant in this case.
Okay.
I'm also an attorney in practice.
Do you want to reserve any time?
Oh, thank you. 5 minutes is
That's fine,
enough.
thank you.
There are 3 assignments of error in the brief. The first assignment of error has to do with the removal of the trial court magistrate. The second has to do with an error with respect to child support arrearage, and the third has to do with a motion on a show cause for contempt having to do with an insurance issue.
Am I correct that the total amount of damages or the total amount at issue is $3.84, not something higher?
That's not a typo. It's $3. $3.84 plus processing charges of $251.80. I intend to withdraw the third assignment of error. I think when it made its way into the brief initially, it had a function that really is no longer applicable. There has been no contempt finding, and so I don't think that is an appropriate assignment of error. So I'd like to withdraw that and just reference the 2. In addition to that, I want to point out that there's another case pending before this court on a writ of prohibition that was filed on March the 3rd after the briefing in this case was done, and that's case number 28149. And that writ was filed because on the 4th of March, the next day, the trial court, despite the pendency of this appeal, seeking to remove the trial court magistrate on the grounds of bias and prejudice, intended to proceed with the hearing, with a motion for contempt on the following day. I learned that sometime during the course of the week, and the trial court was aware of this pending appeal, but apparently believed that the fact of this appeal and the assignment of error didn't preclude it from proceeding motion for contempt. I point out the related case for that reason, and also to say that attached to a filing that I made on April the 22nd in the other case, 28149, is what's called a notice of change of magistrate, and it appears to be entered on the 16th of March, based on the heading at the top, and it doesn't reference in any way reference the appeal or the claims of bias or prejudice, but it indicates that the case has been reassigned by the court to another magistrate, Maureen Foley. And it says the motion hearing previously set before Magistrate Guy for March 4 will be rescheduled forthwith. A separate notice will be forthcoming. In fact, that has been rescheduled for I think sometime in August.
So the only thing left is what?
Well, with respect to the notice of the change of magistrate, as I say, it isn't clear to me whether this is for purposes of the hearing or whether this is a permanent reassignment based upon the finding, based upon the appeal relating to bias and prejudice. In other words, I can't tell from this whether the scope of this reassignment. As I say, because it doesn't make any further, there's no further narrative in that. The other thing I would say is that, as the court doubtlessly is aware, the hearings in the domestic court are exclusively, almost exclusively for the magistrate. And so, you know, I had no contact to speak of at all with the judge, other than the judge entered orders almost simultaneously when the recommendations of the magistrate were filed. I had also sought and do seek a reassignment of the case to a visiting judge. I know that is often in...
I'm sorry to interrupt again, but what I'm trying to understand is what's left of the case for the purpose of this appeal, and what should we be learning from this dialogue today?
That I believe that this court should order that a visiting judge be assigned to the case. And the reason is that although the bias and prejudice that are the subject of the affidavit related to hearings before the magistrate, ultimately the trial court judge signed the orders. And so
Well, the only thing we have in front of us today is regarding the actual magistrate that was on the case. That your assignment of error is that you felt that the magistrate was biased and prejudiced against you, and you should have had a hearing at least in regard to your motion to have that magistrate removed.
right.
So we don't have in front of us today, right? You have not assigned as error that you should be getting a visiting judge.
You're correct. It's referenced in the reply brief. It's also in the related case having to do with the prohibition.
But my point is, we don't have an assignment of error about a visiting judge, and even if we did, I'm not sure that would be properly before us, because that's more of an affidavit disqualification with the Supreme Court, wouldn't it be, to get a visiting judge?
It seems to me, well...
I mean, that's a kind of a scary proposition if we three judges up here can just start
yeah.
reassigning judges.
Yeah.
So anyway, why don't you proceed on, I think what Judge Moore is concerned about is what assignments of error are remaining here today. The only one you're withdrawing is the third assignment of error, right?
That's correct.
Okay.
And the second assignment error, and of course as Judge Whitmore points out, the amount of money is next to nothing. It is somewhat significant though than when a lawyer admitted to this practice is found to be in any amount in arrears. It has implications professionally and otherwise.
Yes, but you don't need to bring a lawsuit to charge unprofessional conduct. If you believe it was a disciplinary matter or something of that nature, there are other avenues.
Yeah. The trial court, after an administrative hearing, found some arrearage that doesn't exist. And I'm a little bit surprised that I'm even talking about this, not only because it's a so small amount of money, but I believe that the other side agrees with that there has never been an arrearage of any child support, a payment of over nearly $1,000 per month for 10 years now. What sometimes happens is administratively when a payment is made toward the end of a given month, it gets entered the following month. And so there's some delay there. But how or why there is found to be a $3 arrearage and then processing charges, I don't even know how or why that's the case. So as I point out in the brief, I thought it was agreed and that there are no arrearages, and yet that's what the trial court found. So those are my comments. Unless there's any other questions, I'll stop.
I don't believe so. Thank you.
Good morning. May it please the court, I'm Arthur Axner and I represent Diane Zaryki, the appellee in this case. I'm compelled to point out to the court at inception that the only order on appeal is dated September 2, 2015. And that order addresses two issues only. One is the denial of Mr. Breen's objections to the magistrate's decision that was issued on April 30, 2015, and the order denying his motion to disqualify Magistrate Janice Guy. The hearing before the magistrate on the child support issue was conducted on April 14, 2015. And as I told you, the decision was dated April 30, 2015. Mr. Breen filed objections to that decision on May 15, 2015. The docket of the trial court will confirm that Mr. Breen did not support his objections with a transcript of the evidence and proceedings conducted before the magistrate. And in fact, he failed to support this appeal with a transcript of those proceedings conducted before the magistrate, and he's therefore not in compliance with Appellate Rule 9B and C. With reference to his assignment of error number 1, I submit that it is moot, because on March 16, 2016, the Domestic Relations Court issued a notice that it was reassigning the case to a different magistrate. Throughout my involvement in this case, Mr. Breen has been asking the trial court to dismiss Magistrate Guy without supporting that request of bias and prejudice with any supporting documentation or evidence.
Excuse me for being confused, but the new magistrate was not Mr. Guy.
Janice Guy was the one who was removed from the case,
Right.
and the new magistrate is Magistrate Foley.
Okay, thank you.
So, in final analysis, Mr. Breen has been successful in having Janice Guy removed from the case.
Well,
And she is assigned to it for all purposes. That's my understanding.
There's a judgment entry in the record to that effect.
I'm sorry, I didn't hear.
There's an entry in the record to that effect.
There is.
okay.
And that was issued on March 16th.
Okay, now I'm confused. All right, two things. One, I understand the assignment of error pertains to her removal. So your position is, since she is removed, that resolves the issue because his underlying complaints are untimely, so we can't look at the merits of them anyway.
That's correct.
So that dovetails each other. Then number 2, though, what's to prevent, if we do not find, if we do not rule in the merits of assignment of error number 1 and say she should or should not have been removed, what's to prevent the trial judge from reassigning Magistrate Guy to this case?
Nothing,
So how would it be moved then?
because the request throughout was to have Magistrate Guy removed. And he's been successful in that regard. And I
But she
can't,
hasn't been, his request was to have her removed because of bias. She was not removed because of bias. I don't think, correct me if I'm wrong, but I don't think Judge Dezo has issued an order saying I'm removing the magistrate because of bias. I would assume probably what happened is just because of all that's been going on, she's just probably recused herself.
I have to agree with the court. And the judge did not issue an order. It was issued by the individual who administers the court.
That, yes.
If
Okay.
I may address assignment of error number 2, Mr. Breen is suggesting to the court that the court erred in its order that there was a child support and processing fee arrearage. His argument, however, does not address that issue. Instead, he argues that the court should not have overruled his objections to the magistrate's decision, which was filed on April 30, 2015. The objections were filed more than 14 days after the decision was issued. The 14-day time period set forth in Civil Rule 53D is in effect a statute of limitations for a party to object to a magistrate's decision unless within that 14-day time period a request for an extension of time is filed. In this case, Mr. Breen did not request an order extending the time within which to file his objections, and thus the objections on their face are untimely. The trial court did not abuse its discretion when it recognized the untimely filing and its order that the objections were to be overruled. I submit to you that assignment of error number 3 has no relevance to this appeal because it is not based upon any order contained in the September 2, 2015 judgment of the trial court. It therefore has no standing in this court. Simply, if Mr. Breen wanted to schedule a hearing on his post-decree motion, which he filed on June 2, 2015, he simply had to contact the scheduling clerk of the court to arrange a hearing. The face of the motion shows that the notice of hearing was simply crossed off, at least the one I have in my files like that. Regardless of all this, the record will confirm that on March 3rd, 2016, the trial court issued a notice and scheduled a motion hearing before the successor magistrate for August 8, 2016. Diane Zaryki's motion to show cause filed April 8, 2015, and Mr. Breen's motion to show cause filed June 2, 2015, will be before the court on that day for consideration. So the court can understand, the initial hearing was scheduled for June 18, 2015. On June 17, 2015, Mr. Breen filed a motion to continue the hearing because of an alleged back injury. Diane had traveled from her home in North Carolina to be present for the hearing, and she was present when the hearing commenced. Mr. Breen was able to participate by telephone. However, since he was not personally present in court, the magistrate who he claimed was biased and prejudiced against him refused to consider the merits of Diane's motion and adjourned it for a later date. On September 28, 2015, a magistrate's order was issued scheduling the hearing for March 4, 2016. On that date, both parties were present in court for the hearing, but once again, the hearing did not proceed on its merits because Mr. Breen wrongfully argued that the trial court did not have jurisdiction over the motion because of the pending appeal, and also because this court had issued a stay order.
Okay, now I'm getting confused again. Are we still talking about assignment of error 3?
I'm sorry, Your Honor.
Are we still talking about assignment of error 3?
Yes,
Okay, and that's when he's withdrawn?
if he withdrew it, I did not hear it.
Yes, fine, I'm sorry, he withdrew it, so I just thought maybe you,
No,
okay.
so that's all I have to say. Thank you very much.
Oh, well, that's fine, thank you.
I think Judge Schaefer has a question.
In domestic relations court, if you have an issue with the magistrate, can you make a motion to the judge to have the judge hear your case, or do you have to stay with the magistrate?
You can attempt to have the judge consider the motion, but as a practical matter, it doesn't happen. When the case is assigned to the magistrate, that magistrate hears everything until you get to a final hearing. Simple as that. Any other questions? Thank you.
Thank you.
Thank you.
You have 5 minutes.
I just have a couple of comments, and I'm sure I won't even use that much.
Okay.
It seems to me, Judge Carr referenced in the notice of change of magistrate, that magistrate guy recused herself. That sounds like there's some action by the court, and just for clarity, I don't want to beat it to death. It's a notice that the case has been reassigned, and it's all of 3 sentences. It just indicates that the court administrators reassigned the case. So the point here, there is no order, there's no tie of this action to anything that is before the court relative to bias and prejudice. The business about filing a transcript relative to this hearing on assignment of error 2, as counsel knows, there was no transcript. There were no witnesses at this meeting. with magistrate guys. So there certainly was nothing to file. As to the timeliness, I think counsel misspeaks when he says it's like a statute of limitations. It's not jurisdictional. What happened was, as I look at my own, the first paragraph under assignment of error number 2, it looks as though I assumed that 4 days mailing from my office in Fairlawn to the court would have been sufficient. It turns out it wasn't. You know, they were sent down on May 11 and got here on May 14, a day late. That is not a jurisdictional flaw, and the court can take that under consideration. I think that's all I have. Thank you.
Thank you. Thank you both for your arguments. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, and you can look on our websites too. Please enjoy the rest of your day.
Thank you.